Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Hello and welcome to the podcast. We call it Your Inheritance because your inheritance may be what's at issue in your life. Issues about family wealth and legacy is what folks like you watching this podcast may be legitimately concerned about when that time comes, when a beloved parent or a dear loved one, a husband or a wife, or a life partner passes away. So in these podcasts, we cover a broad range of topics with respect to trust, estate, and inheritance issues, some of which may be your inheritance issues through discussions with other attorneys, legal professionals, today a very well-known real estate professional, and professionals involved in the fiduciary management of estate and trust assets. Our discussions are confined to the state of California. Nothing we're discussing today is legal advice to anyone, and nothing you view should be considered legal advice. If you need to give us a call at the office, you may, or contact the attorney of your choice if you have a particular legal matter that requires the advice of an attorney. Now, today we're going to discuss real estate issues through the probate process and through trusts, focusing on the probate process and its perspectives from a broker realtor. And our guest today is Mr. Bill Gross. Bill was born in Santa Monica. Hi, Bill. Thanks for coming on board.
Thanks so much. Glad to be here.
Okay. Bill was born in Santa Monica, Southern California guy, raised in Orange County, has lived in the Inland Empire, where I'm situated now in beautiful Palm Desert, California, out in the desert. He's lived in San Gabriel Valley, South Bay, and for the last 20 years, he's lived in the west side of Los Angeles. Bill has been in real estate for over 30 years and is currently the broker associate for EXP Realty, I think I've got that right, and has literally closed thousands of transactions and gives help to all of his customers to achieve their goals. And as is relevant to your inheritance, this podcast, Bill has a significant presence, very significant, in the sale of property in probate matters and out of trusts and out of estates. And I want to just spend a little time. One testimonial on Bill's EXP Realty website states in part, real estate has become very niche specific, and Bill Gross is the go-to expert in probate, trust, and inherited property sales. Not only is he the authority in this space, but he imparts knowledge to other agents and brokers in an easily digestible fashion so that others can capture their share of this pool of motivated sellers tasked with the selling of a loved one's home. So just to give a little bit of how I look at it, coming from a standpoint of a probate lawyer, do litigation, do regular straight up probates, that probate sales, if you don't have full authority to sell a property, they have a very specific process associated with them. A lot of people don't know about that. Even lawyers who are regularly in probate court, perhaps handling matters in litigation, trial attorneys, which is mostly what I do, or probate estates where the executor or the personal representative is granted full authority under the California Independent Administrations of Estates Act, what we call the IAEA, which everybody wants to get if you can get it. It's a piece of legislation under the California Probate Code. If you don't have that authority, you might have very little experience with going through the sales of real estate through a court supervised process, which is very particular. It's very form driven, and it's got a lot of steps to it that are, a little bit daunting for the uninitiated. Now, the IAEA grants to a personal representative or executor the authority to administer most matters regarding an estate if you get it. If you check that box, if the court gives you a court order and your letters testamentary say that you can have that authority, you don't need court supervision, and you'll file your appropriate paperwork throughout the course of the probate, and then the next time will see the judge, you should have to see the judge, could be when you do your petition for final distribution. But Probate Code 10308 provides that all sales of real property, whether by private sale or public auction, shall be with court confirmation process unless you have that authority, full authority under the IAEA. If you don't have that authority, you got to go through the court supervision process. So my first question for Bill is that, first, how long have you been in real estate, and what caused you to get into probate sales?
I started in real estate in 1986, so that's 38 years. And I built a business and grew, went into management and coaching and executive management. And about 5.5 years ago, realized, hold it, I don't want to be in management. I wanted to own my own business. That's why I got into real estate. And so at the age of 60, I relaunched my sales business, but I knew I wanted to focus on a niche. And I had done some probate. I come across, like most realtors, I was aware of it. I knew it was different, but I really didn't understand it. And so I took the time to take several classes and really learn it. And then one of the teachers challenged us to go to court and watch what happened in court. So I went to court one day, and I was comfortable going to court. My father had been an attorney. It was fascinating. It was like watching, divorce court or Judge Judy in real life. It was better. Right. And I went back, and I was addicted. And so I went originally for a day and then a week. And I said, hey, this is a business, because I found both families needed help. The attorneys were not able to give them the help they needed in the way they needed it. And the attorneys needed help on how to work with their clients better, particularly in probate and real estate. And so I just saw the need. It was right in front of me. So about 5.5 years ago, I really launched all of my efforts into probate real estate.
That's very interesting. So from your realtor broker perspective, I'll weigh in with my perspective, because I do have a perspective. And my perspective is this: there's a dearth of people out there in the real estate world who really know the process, and they're not familiar with the process very well. But from you, they're great people, they're great, otherwise might be great real estate agents, but when they get into this space, they're not familiar with what you got to do, all the way through having court approval, all the way up through maybe even having a little bit of a bidding situation at the courthouse if there's an overbid situation. But from your realtor broker perspective, how are probate sales in California different from a standard sale?
Well, the answer, I would say 90% of probate sales don't require court confirmation.
Right.
So they're not a problem until they become a problem. And what I mean by that is that 90%, oftentimes you have a couple siblings and everything's great. And then all of a sudden, you decide to sell the property, and everybody's happy, everybody loves each other, and they go, oh, gee, here's a notice of proposed action. We're going to sell it for $500,000, but Zillow says it's worth $600,000. You're selling it too cheap. And next thing you know, you have a conflict. And so the normal probate process, I always tell realtors, there's only a few things that are different, but you have to master those few things. Have a clear strategy on getting to the notice of proposed action so that you can close the escrow. Really important to understand who the players are in that process. On the 10% of court confirmation, like everything else in life, I think most attorneys don't know the process at all. And the challenge is, being willing to say, I don't know. And so that's all I do. I mean, I list and sell these properties all the time. I literally track every single such sale in LA County. Is about 30 or 40 a month. I have a database of every one for the last 5 years, who the attorneys were, what the results were, who the bidders were. So it's one of those things where, again, it's not a problem unless there's a problem. And I think for most people, though, those are problems because they get delayed 2, 3, 4 months. They cost customers thousands of dollars. Sometimes you can avoid the court confirmation process if you know how to, I don't want to say cut corners, but round the corners properly. There's things that courts will accept that I've seen happen. So again, to answer your question, 80% of the time it's a regular sale with a couple pieces of paper. But if you're one of those 20% that's not, it can make all the difference in your experience.
You're correct. I mean, particularly if someone's selling the property out of a trust and there's no issue, the property is properly titled to the trust, and the trustee just sells the property like anybody else. You're not in court at all for the supervision.
Right.
The trust isn't in court. That's why people do trusts.
Right.
But if you have to have a property that doesn't come into the trust, you couldn't do it by way of what we call a Hegstead petition to title to the trust, and maybe you have to do a probate, or you didn't get that full authority for some reason. You didn't get that full authority. You're selling it. It was previously in a conservatorship or something like that, or it was an intestacy, and you didn't get the full authority because there is no will, and for whatever reason they don't check the box. You have to go through this process, and you have to actually file a petition for approval of the sale. And there is a significant process for that, and there's a lot of rules with respect to how you can even hire a realtor. And for example, you're supposed to the listing agreement is limited. I mean, for it, generally speaking, do you have experience with that? The time frame on the listing agreement?
Yeah, in California, a probate listing cannot exceed 90 days. So oftentimes you'll see a realtor, excited to list a property and list it for 6 months. It's technically invalid. Also, different courts have different local rules. So in LA County, the local rule is for single family homes, the commission can't exceed 5%. You'll see realtors who think, oh, I have control and it's my deal, and I'm going to do it at 8% because I'm a great realtor. But the court wouldn't approve it. It doesn't matter. And now there are exceptions, and you can document. There's a process, but there are local rules you can be aware of. And so the first thing I do when I get a listing is I go to that county's probate division and look at the local rules and see what they are and what they require, because they're usually posted in a PDF document. They're not mysterious. They're written in English. I understand that they're for attorneys, but the truth is they're all written in English. So my job is to read them and then maybe ask questions if I need some assistance.
Yes, and we did a sale recently that was part of a settlement agreement out of a disputed trust matter. It actually was a sale of a Palm Springs residence, but it did relate to the court that had control over the sale, and they wanted to have supervision over the sale was LA Superior Court. And so, we're familiar with those rules, and you have to go through the process. I'm sometimes surprised when I'm dealing with the agents on the other side, the buyer's agents, that they're not that familiar with this. And we have to tell them. I say, I know we have an offer, but your offer it's an offer, but we have to have it approved by the court. And what we try to do is make sure that when the offer comes in, if the personal representative is responding to the offer, that we lay out in the paperwork very clearly what has to be done in the counter, and says that we'll say this is going to take some time. We have to file a petition for approval. It'll take this much time. The court date is going to be whenever it is. We have to give so much notice, so on and so forth. Do you ever find that you run into situations where the purchaser's agents on the other side are not familiar with that, and does that sometimes frustrate the process of the sale?
Well, I think that's the opportunity that I present and the value I create for my clients and attorneys, which is 90% of the agents have no idea what they're getting into. They just see a house, the buyer wants it, and in this market they make an offer. So my job as a listing agent is to coach the buyer's agent on that process. So I, in my MLS, put the proper remarks, what forms are required. I'll put whatever information they need to have. I've actually recorded YouTube videos on the process so they understand what that looks like. I'll walk them through it. I generally don't double in my own deals without my client's specific approval, because oftentimes, and it might sound callous, but if you're hiring me to get top dollar for your client, you may not want me to scare off the buyer. You may want me to get the buyer locked in, and they may not know the ride. It's kind of like putting them into a roller coaster. They may not realize how many bumps there are on the roller coaster. But if you're my client, you may not want me to tell them that. You may want me to get them into the transaction, and then my job is to soothe them along the way until we close. So there's different circumstances, but in general, my strength, my focus, that's why I did my podcast, Probate Weekly, is to educate the other realtors on my listings, because that way I end up getting the best results for my clients.
Yeah, my philosophy always is that when we're doing these things, and I'm representing a personal representative, I just say, look, we have to be totally upfront with everybody. We're going to tell everybody what the process is. You know, they might not want to hear that from the lawyer or the personal representative, but it's really important that people know that we can't always turn on a dime. And if someone comes in and we want to close escrow really quickly, we have an all cash offer, can we do this right away? I say, no, we can't. I've got to get a court date. Right. You may very well get this property, but we've got to do that. And so what do you do in circumstances like that? I mean, sometimes you might, if someone doesn't want to wait, you can't force them to wait, but how do you handle that?
Well, I think, each of those circumstances are different. So in some cases, I'm trying to show them why. I believe at court confirmation sales, the original buyer will usually go into court with about a 5% discount to the market price for that property. And so I tell them that it's not a 20% discount, it's not a 30% discount, but on a $600,000 property, 5% is about $3,000 you're saving by going through this process. And I'm an expert in that area, and I'll walk you through what all that means and help guide you through it. So I feel like my job is to make it as comfortable and easy for a buyer's agent and a buyer to go through. That's my job. At the same time, it's to protect my seller if something goes wrong. So sometimes the sale gets delayed 30 days. Well, if it's my client's best interest to keep the buyer connected, I'm not going to tell the buyer's agent, hey, if you read the fine print, you have the option to cancel. I mean, it's in there, it's in writing. We gave them the form. I told them to include the form. But I don't want to tell them that, because that undermines my client's interests. So it's one of those things where each circumstance is a little different. But on offers coming in, there are buyers who just can't close. I'll give you one example that's not well known. There are buyers who think because it's a probate, they have to pay all cash. That's not true. A buyer can buy you the property, let's say an FHA loan, and they do all the due diligence and get the appraisal. They just need to then lock in their approval through the court date plus 10 days. Because it's the overbidder that has to come in with 10% and close all cash, no contingencies in 10 days. And so many listing agents mistakenly keep properties out of the market from first-time buyers that are suitable for them, maybe not, but I think you have to know the law, and the law is not that the buyer has to pay all cash, it's that the overbidder has to be willing to come in all cash. So again, my job as a listing agent is to try to sort those issues out and get people in the right lane, and the ones who don't qualify, get them off that lane so we don't get tied up with them. Wholesaling is a big issue also. You'll find people willing to bid on the property and tie you an escrow, and then you file your notice of court confirmation, and you realize the buyer has no intention of closing. So now what are you going to do? You've wasted your time. You filed the paperwork, $350 filing fee, attorney's fees. So again, my job as a real estate agent is to sort that out and make sure everybody knows what the process looks like.
Yeah, I had that happen, unfortunately. We got to the courthouse and having the discussion, and folks had didn't really understand the process and really weren't ready to go forward, and so we had to just go and do it again with another petition, and that happens from time to time. So I want to get on a more personal nature with the question that relates to clients in these types of situations. A lot of personal representatives, executors are going to be family members, a son, a daughter, and notwithstanding have good probate counsel at their side, they're now faced with the task of selling mom or dad's house. It's an emotional issue. They're experiencing the loss of a loved one. You're going to be interacting with these people. Do you have an approach with dealing with and helping folks in this situation?
I think you have to expect that if you're in this space that I did a coaching call yesterday with agents and said that I think you have to have a wider range of communication skills, because I'll deal with somebody who's never bought a house, who's inheriting one. They have no money. They're overwhelmed with all the tasks, to a very experienced corporate attorney or probate attorney. And the communication levels are totally different. And I've talked to both of them on the same deal. And so I do think that success in this field requires not just the technical skills, but a real focus on the soft skills of communication, listening, and learning how to document, learning how to not get emotional. I have people yell and scream at me all the time, and I just don't let it bother me. And they'll come back and apologize. I say, that's fine. You're welcome to. You can't do it in front of my wife. You can't do it in front of my kids. But to me personally, I really don't care. That's part of the job is dealing with people's emotions and such. So to answer your question, I think it is an area that requires, I think, empathy, understanding, being attentive, and knowing that the people you're dealing with, right now we're trying to close. This lady's she's on welfare. She's basically on drugs. She's inherited a house. She's never sold anything in her life, and holding her hand through the process has been hard. But that's my job. My job is to help her get the results that she wants.
And we want to treat everybody who's in this position with the respect and the dignity they deserve. And a lot of times it is a new thing. Yeah. And sometimes we do find unusual circumstances where people are coming into this type of transaction. It may be the first transaction of any size they've ever been involved in their entire life. And so you're right. I think what you said, having a broad range of empathy is a good thing, because the bottom line is we've got to follow the law. We've got to follow the law. We've got to follow the law. That's what we do. We play it by the book, and we want to help people, and we want to help people, close a chapter in their life that involved a loss, and that's where an experienced I can't say enough about it from my own experience. An experienced real estate agent who knows the process and knows that, look, everybody's got to cool their jets through some of it, because otherwise if people are amped up and they think it's like a regular sale, then their expectations are artificially high for when it might close. And that's going to be defeated by the fact that they have to go through this process and may have to go to court, and someone might overbid on them. So let me ask you a question here. What is the timeline for a probate sale, or more importantly, how do you prepare both seller and purchaser for the additional time involved?
Well, again, everyone's a little different. And you have to, I think, what I do when I take a new listing is I have a checklist. What I do is it forces me every listing to go through all the steps and update it and say, okay, what are we doing on this? Lock boxes, showings, full authority, limit authority, court, not court, what court is it in? Very different LA court versus Riverside, San Bernardino, or Orange County. So those are all things that we have to do on an individual basis. I do think that knowing what I know and then also sharing what we don't know. I'll give you one example. Is I have a very large estate, $40 million estate, and the attorney is applying to take one piece of property out of the probate and distribute it. There's only one heir. So it's a preliminary distribution, and there's a whole filing and reason why he's doing it and such. And so there's a person who wants to buy that property. That's why we're doing it. And he's asking me, what timeline is. I said, well, to be honest, our hearing's not till August 16th, but nobody knows what the judge is going to do. The judge might approve it. The judge might say, gee, that's a good argument. Let's set a hearing and I'll review that 3 months from now. The judge might say, are you crazy? I'll never approve that. And we go back to square one. I said, so nobody knows. We have to be prepared for all three scenarios and have a game plan for all three. And so the buyer didn't like the answer. The buyer's not my client. My job is to prepare him as best I can. And I just said, this is not a case where you're going to get an easy answer. This is a very complicated matter. And our attorney is trying to do something that's very cutting edge, very aggressive, I think really clever. Maybe it works, maybe it doesn't. So we'll see. So it's one of those things where I think sometimes you know certain things. I'll give you one example. I literally track every LA court filing in LA County. So when an attorney says to me, well, if we file a Hegstead petition, to use the word you used, or if we file a spouse petition, we file a new court confirmation, what date will be set? Well, the answer is it depends on which department you're in. And I can tell you, though, last week there were 3 such filed, and the hearing dates they got were A, B, and C. So I know the actual date. Sometimes attorneys will say, oh, well, they're 30 days out. I say, no, they're really backed up. Now it's 90 days because I have the actual data. So again, I think the key is to focus. You have to know what you know and know what you don't know, and then just be transparent as you can.
Right. And LA, I think they really do try to get the sales, squeeze them in on the calendar if they can. I mean, I've noticed that because I've seen where other petitions will be way out, but the petitions for confirmation of sale, they do try to keep it within the statutory time frame. But then the other issue you have to have is you want to make sure your I's are dotted and your T's are crossed, because you have to go through the probate examiner, and the probate examiner is going to issue notes. And sometimes in Riverside County, they're really good. If you'll get notes, typically on a typical petition, the notes will come out 30 days, 13 days, and 3 days before the hearing, almost lockstep. They'll be checking it that way.
Right.
So you have an opportunity to cure the notes. If there's some defect or they have a question, you've got your notes, you got a deficiency note. Hopefully you don't have a deficiency note from the probate examiner. And to our viewers, probate examiners are folks that work for the courts. They're very good people. They're typically attorneys, but not always. And because probate is such a technical field, they review every single petition that comes in, almost like an auditor, and look for deficiencies. Are the calculations right? Do you have the right sale? And for this particular thing, did you calculate the overbid correctly? Is your appraisal within the year was it supposed to be, and so on and so forth? Have you given notice to everybody? Is everybody they check it against the petition for probate, make sure that everybody's gotten notice of the sale, so on and so forth. And so there's so many things. And if you've got any deficiencies, my experience in LA sometimes is they're so busy over there that sometimes the notes don't come out till kind of close to the hearing date. You might not have a chance to clear them, but the judges they'll try to do as much as they can, but it's, again, you have to explain it to people. I tell the agents on the other side, they'll say, is this going to close on that day? We want to know if it's going to close on that day. Our buyer wants to buy it on that day. I say, well, if the judge approves it on that day, it will, and we think we've got all our I's dotted and T's crossed, but be prepared, because someone might show up to the court and he might have to open his checkbook for a little bit more money because someone might overbid that property, because it's a statutory process to ensure that the highest and best price is obtained for this property through this court supervised process. And so I'd like to ask you a question, talking about the practical aspects of a sales transaction and understanding that personal representative and executor has a statutory duty to obtain the best possible price within reason, and within the inventory and appraisal process associated with the probate code that applies to the particular case. Is it your experience that purchasers who are looking at these properties or try to lowball the sale, or that's not so much a problem?
Every buyer wants to buy every property on a lowball price. I mean, that's just the reality of life, right? And every seller wants more for the property than it's worth. And the market meets somewhere in the middle, and that's what determines the market. I think the key on those court-confirmed sales is the wider the net you cast, the more likely you are to get a fair price. What happens in some of the court sales is listing agents or sellers or petitioners, personal reps, have a friend, maybe there's 5 heirs, and the petitioner feels like, well, I'm really entitled to this property, but I can't buy it, so I'll sell it to my friend on the cheap. We won't put it in the MLS, we won't show it to anybody, we'll degrade the property somehow. And, I represent investors who look for those properties. We watch every one of them. Nothing slides by us. So when I see it off the market, I know the probate examiner will note that it wasn't listed in the MLS. It wasn't listed property. There's no photos. They didn't allow showings. We'll request showings. They'll give them to us. I'll make a note to the attorney. Hey, the probate code requires you to show the property, market it properly. So to answer your question, I think the answer is, I think there were days when there was less transparency and properties were sold kind of on the cheap pretty commonly in probate. And a lot of the training as a realtor was, hey, you could double end the deal, and then you buy it as an investor, and then you flip it, and then you resell it and make money and make 5 times commissions. Those days are over. I think with the transparency of computers, the internet, Zillow, Redfin, the courts, I think that, like I said, I do think that buyers on court-confirmed property should look for about a 5% to 3% discount for that same market value property, but you're not going to get much lower than that.
Right. And what I tell people on the other side, I say, look, we've got an inventory and appraisal. We do everything by the book. We get the proper appraisal. It goes to a court appointed probate referee. They check that out. They sign off on the price, and then you have to get at least 90% of the appraised value within the past year. So if someone comes in and says, well, you got to go through an approval process, but we're thinking we can still negotiate. I said, well, you won't be able to negotiate below 90%. I mean, we have to, your bid has to come in at least 90%. And so it's pretty tight. And so that's the assurance that for people on our end, that we can deliver to our clients and to the personal representative and to the heirs, that they're getting the best possible value for that property. Now, do you ever attend a hearing in probate court with a buyer or a seller?
Yeah, all the time. Any listing I do, I always go to the court. I just find there's things that you see or hear you can't do on, even though we have Zoom or LA Court Connect. When I'm a listing agent, for sure, when I'm representing a buyer who bids, for sure, I go to the court in person.
Right. Have you ever had experience with any interesting stories about the overbid process sale where it's gotten, where there's been some, this is a really good property that you've got listed and the first bidder comes down there and is ready to close. He's within 90% of the appraised value. It's all set forth, and then the court makes the announcement. The attorney's done the interview. Is there anybody here to overbid? And then that process starts. Have you had any experience with that?
It's the greatest. I can tell you stories for hours. I think one that would interest you is, so I had a conservatorship. There was a man who was incapacitated, and he had a lot of property, but he bought these little remnant properties that when there was zoning changes, just little excess pieces. So we had a property in Buena Park, and it was in the residential area, but you couldn't build a house on it. But it was worth about, $40,000. And you could park a boat on it or park a trailer on it or something like that. So the guy next door had kind of illegally put a fence around it, and he was using it. And so when it came time to sell it, I contacted him and said, listen, I appreciate you doing that. We're not going to go through the process of, evicting you. We don't need to. It doesn't make sense for, our finances. We're selling the property. He goes, well, I'm not willing to pay more than $10,000 for it. We got to your point, we got the inventory and appraisal report in, and I think it was like $30,000 or $40,000, a reasonable price. And I said to the guy, look, I'm going to put it on the market. I'm going to get flooded with people who want to buy it. He said, I don't care. So we put it in the market, and we got like 20 offers, up to like $35,000, $40,000. And I said to my client, look, we can accept the $10,000 because I know we're going to go to court, and these other people are going to show up to bid. Nobody's going to let a property in Buena Park, California go for $10,000. It'd just be a scene. And so we did, and we actually got to court, and there were like 20 people showed up, and it sold for $40,000, which was more than 90% of the appraised value. And my state got what they wanted, but my state got to avoid the litigation with this next door neighbor. We basically sold it as is, disclosed it. Hey, we have a hostile neighbor. There he is. Here's a picture of the fence. You're buying it with all that baggage with it. And my seller, just, a nice young woman, just wanted the cash and was able to walk away. So I think the moral of the story to me is the system is set up to protect the estate. It's set up to protect the state and the county and the community. And so if you follow the rules, it should end up that way. And that's what they're really designed for.
So you've seen some spirited bidding processes.
It was a madhouse. There were so many people there, and the judge was just so pissed. But and it's a small amount of money. My commission was like negative because I have fees I pay to administrators and such. But it was part of a big estate. But my point was, my customer just wanted the $40,000, and we got it for her, so she was happy. But it was there must have been 40, 50 there that day in the courtroom.
Bill, you got the broad range, 40,000 to 40 million. You got the
exactly
a whole lot there, and that's how it goes.
Yes, especially probate.
Talk for a minute from your perspective. Are there levels of disclosure on the initial documents, the acceptance, and so forth that involve more disclosure, in your opinion, about what the process is than ordinary? I say, look, we don't want problems with buyers who don't know the process, or buyers agents who are too eager to get through it, and are going to be making demands and calling, we want to be very polite and professional. So I usually say, if you want me to help you with this, you got the offer, make sure that let them know. I mean, where we're at. Let them know when you're listing it. Let them know on the flyers, in my opinion, when you're showing the house, that this is a probate sale, and there's a process involved, so that the buyers are not don't feel like they've been derailed because they're looking for something else, and they feel like, oh, I could have had this opportunity over here, and now I'm sidetracked because this is going to take a little bit longer, and I don't even know if I'm going to get it necessarily. Although I would say that 90%, the overbid process is not overwhelmingly. Most sales don't go to an overbid process, I would say. In your experience, probably not.
No.
I mean, there might be some people that are down there, they're sophisticated overbidders, right? That are spying, checking on these things. But if you're within 90%, they're not necessarily scooping up a deal if they come with an overbid anyway. But do you to make sure that things go smoothly? Are you more thorough in the disclosures? Are there more steps involved in the disclosures on the standard documents for the purchase and sale?
Well, the first thing I try to work with the attorney to say, that's my job. There's no reason why an agent should ever be contacting the attorney, because we as realtors are cooperating theoretically. And just like I'm not allowed to call my other realtor's client, they should be calling my client's attorney. So I think that's one of the key things, is getting control of the process. In the listings, we do have, in the Westside LA MLS, we do have checkbox for probate, yes or no, court confirm required, yes or no. It's a little misleading, as you know, because you can say no, but you discover later that it is required. But in the remarks, I also put court confirmation may not be required, which is the proper verbiage, and must include a purchase agreement, probate addendum form, PAPA. I upload that to the document section. As far as disclosures, the truth is probates have slightly less disclosures than a regular seller, because presumably, unless they live in the property, there are things they're not going to know. So certain forms they're exempt from. But I do encourage all my clients to disclose anything they know, not to research, but to disclose what they do know. And then if we can do the disclosures and upload them before we market the property, then every buyer has a chance to see those in the pre-marketing phase as well as during the escrow. So yeah, I think disclosure is critical. But again, to your point, as far as the probate process, that's my job as listing agent, to educate the buyer's agents. And I even have, like I said, YouTube videos I put in there to say, this describes the process. If you have questions, please feel free to call me. And I talk to realtors about that stuff every day. I literally coach realtors on this process every day, all day long.
Great. Now, many practitioners out there, colleagues of mine, lawyers who may be a bit new to the probate sale process, do you have resources that you make available from your firm to maybe help buyers, personal representatives, attorneys to navigate the process?
Well, one is I have a podcast.
The lawyers are supposed to know the law, but it's very helpful to have. It's very helpful to have an experienced person who knows the process. I can tell you that for sure.
Well, I think I'm kind of like a free paralegal. I try to meet the attorney as early as I can in the process. If they've not yet filed, I try to encourage them to allow me to help them with the publication, allow me to help them with the DE 160, which is the inventory and appraisal report request form, because those are things that, if they're done right, will speed up the process. Done wrong, will cause a problem. It's interesting to me how many attorneys don't know. They finally get the letters, don't know you need to file the DE 160 right away. You should file the publication, notifying your marketing right away if you have a court sale. So those are things where I try to say, listen, you don't have to pay me per hour. I'm free. I'm probably better than your paralegal. There are exceptions. There are paralegals in some of the high volume probate law firms that maybe are as good as me, as know as much, or maybe more, but most attorneys don't have those resources. So why not have a second set of eyes if you're filing a supplement? I watch the notes. I'll notify the attorney, hey, the notes are updated and these are the deficiencies. If there's strategies, I'll point out to them what those issues are. So again, I do act almost like a paralegal on the file for free. And then additionally, I have different resources to help the attorneys. I have a fiduciary service for clients that need a third-party fiduciary that's inexpensive. Administrative support for if you have a paralegal that does this stuff. I don't fill out the forms, but I have a service I can refer to that is very efficient and productive. Advancing money to an heir. I do probate advances. We do loans to trustees, loans to petitioners, or trustees. So yeah, I do bring resources to an attorney to help them, I think, be more, especially the solo practitioner, I can bring the resources that the big firms have.
Right. And again, lawyers supposed to know the law. Paralegals have to work under the supervision of an attorney. You're making an analogy there as to the services you could provide. I think it's very, very helpful to have a real estate agent who is selling an estate property to be familiar with the process. I'm heartened to hear you say that you have the skill set to check the probate notes. That's a wonderful thing to do. You always want to do that. It's actually the first time I've heard a real estate agent tell me that. So that shows that you're deep into the process and you know what's going on. And I really appreciate it. That's all the time we have for today. But I'd like to have you back and we can talk about some other niche issues. It's been great talking to you about the probate process and the sale process. And hopefully there'll be some of our colleagues out there that may see this this podcast, and if they have an issue or a probate sale that they need some help on, they can contact you for that, for handling the sale. Thanks for being with us today. I really appreciate it.
It was my pleasure, Peter. Thank you. Thank you anytime.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.